Good afternoon, and thank you for joining us for an MP webinar covering the 2022 Semiannual Legislative Update, HR Compliance and Employment Law. I'm Katie Kreider, Marketing Specialist here at MP. For those of you joining us on a webinar for the first time, MP is a full-service human capital management company. We offer a complete suite of products and services to support organizations through the entire employee lifecycle, including recruiting, HR, payroll, benefits administration, time and attendance, and compliance assistance. We support our clients with cutting-edge technical solutions, as well as proactive, reliable service and deep HR and payroll expertise. At MP, we are wired for HR and help our clients succeed by aligning their people's strategy with their business goals. I'm excited to introduce your presenter for today's program, Paul Carelis. Paul is the VP of HR Services here at MP. He is SHRM and PHR certified and has over a decade of experience in the HR consulting space. Working with businesses of all sizes and industries, Paul and his team of certified HR professionals assist clients with compliance, training, and full circle HR guidance and support. Just a few housekeeping issues before we get started today. If you would like to submit a question during the program, please use the Q&A feature at the bottom of the screen. We will be sending out the recording of the webinar later today, along with the slides. And with that, I'm going to hand the mic off to Paul.
Awesome. Thank you so much. Really looking forward to today's session, everybody. Thank you and welcome. Really ready to dive in here. So without further ado, just a quick legal disclaimer before we dig in. This is information coming from an HR best practices standpoint. Please don't construe anything today as legal advice. Also, in case you're watching a rebroadcast or a recording of this webinar, this information is current as of January 13th, 2022. And I guess more specifically, with everything as late breaking as it is, as of 1 p.m. Eastern on January 13th. So in terms of what we plan to cover in today's session, we're going to do a legislative overview in terms of what things are looking like in the House and Senate. We'll also provide a COVID-19 update, a lot of news around that lately. We'll take a deeper dive into what's going on at some of the federal agencies. I believe in this session we'll cover the Department of Labor, the National Labor Relations Board, as well as the IRS. We'll talk about some trends that we're seeing in terms of state laws and how those may affect states in which you employ workers, or also just to get an idea for what some of the trends are, as oftentimes some of our, what we consider our influencer states, states like Massachusetts, California, New York, sometimes some of the new laws and regulations that they introduce get picked up by other states as well. So just so you're mindful of what some of those trends are looking like. And we'll do a general outlook of employment trends as well as litigation trends, and finish up with a Q&A and hopefully get to any questions you may have. So again, as mentioned before, please do utilize the Q&A feature at the bottom of the screen, and we'll get to as many questions as time allows. Okay, so first things first, a quick COVID update. We were really planning on having a decision by the Supreme Court on the validity of the private employer COVID-19 vaccine mandates by today. The rumors were that the Supreme Court was going to release a decision on that. They did hold their session earlier today and did not release an opinion on that at this time. So I will recheck before we conclude today's session, but as of right now, it looks like we're going to have to wait a little bit longer for a decision there. So if you were with us last week, you'll know that we did a pretty deep dive into the mandate and the requirements and the expectations for employers. As of right now, that is in effect as of this past Monday. Real enforcement isn't set to really start until February, so we are expecting a decision from the Supreme Court any day now, but as an employer, you should be prepared to comply if needed. If not, then you can decide whether you want to do it. It'll obviously be optional at that point, but we are still waiting for the up and down on that, but that will be pretty definitive once that's released. In terms of subject matter experts that I spoke with, there is some speculation that the overall private employer mandate will be either delayed or halted, and that won't be put into effect, at least not immediately, but that the mandate that applies to the healthcare industry, Medicare, Medicaid funded businesses, that will be in effect, so that there would be a mandate in the healthcare space, but other private employers would not have that requirement. Again, that's not for certain by any means. We do need to wait for the Supreme Court to formally weigh in, and they haven't done so as of yet. In terms of other COVID-related news, as of this time, at least at the federal level, there really aren't many or any federal relief programs to speak of. Those all ended at the end of third quarter 2020. We'll see what happens with the mandate, if it's completely struck down, if pieces of it do stay. If the mandate is found to be valid and continued, there is a requirement for providing some time for employees to get vaccinated. So that could come into play, but as of right now, there's no additional round of PPP loans. ERTC, which we'll talk about in a second, ended as of 9/30, at least for current wages. And the other federal kind of mandated reimbursable COVID sick leave and all of that, ARPA leave and all those fun things, those all ended at the end of third quarter as well. It is really important to familiarize yourself with the rules in the states that you operate in. Several states, Massachusetts, New York, among them, as well as some others, do have COVID-related sick leave programs, many of which do reimburse employers for those wages. So you just want to familiarize yourself with the programs in the states you operate in. Speaking of ERTC, so I wanted to clarify some things there. While the program did end as of September 30th, and kind of with the, at least at this point, failure of the Build Back Better reconciliation bill, ERTC was not extended, or it was taken away and not brought back for fourth quarter of 2020. But that being said, you do still have time to file retroactive employee retention tax credits for 2020 and the first 3 quarters of 2021. So it isn't too late to claim those credits if you're eligible. It's just that the time period in which to measure wages ended on September 30th. So if you are interested, please let us know. That is a service we provide, and we've had a lot of success helping businesses discover thousands and in some cases millions of dollars in refundable tax credits through the ERTC program. And one final kind of best practice piece here, there's a lot going on in terms of reasonable accommodations and reasonable accommodation requests, medical exemptions, religious exemptions, especially for businesses who have decided to have a vaccine mandate outside of what's required by this pending federal law. And to just kind of give a view of how agencies and how courts have viewed those so far, it can be a real struggle if a business has taken the time and effort to put in a vaccine mandate, and they have people claiming exemptions or looking for reasonable accommodations. There is a process you have to go through. We went through it in last week's seminar, so if you missed last week's, please reach out and we can get you a copy of the recording. It was all about the vaccine mandate, but one thing to keep in mind, whether it's the mandate or whether it's a policy that you've put in place, generally speaking, the goal of that is to have a safe and healthy workplace and really free of direct threats that COVID-19 can pose. So when there is a reasonable accommodation, that's fine. We do have to treat it the right way and sometimes go through the process and really determine what the accommodation is requested and whether that's reasonable or not. But should you go through that interactive process and determine that someone has a exemption from being vaccinated, someone has an exemption from wearing a mask, whatever it may be, just because they have a valid exemption doesn't mean that a reasonable accommodation is having them in the workplace. So thus far, at least, when employees have challenged their employers, whether it be not wanting to comply with a mandate or having an exemption and basically being told that they can't be they can't report to work. They're either put on a leave or put on some sort of duty that's away from coworkers, the general public, because of the guidance and the industry information that states that COVID-19 poses a direct threat and is a real hazard. Businesses have been allowed to remove those workers from the workplace. So the most landmark cases so far have been through the airline industry. So several airlines that have imposed vaccine mandates have told employees who have received a medical or religious exemption that if they're in roles that deal with the public, whether that be on airplanes or in airports or wherever, that they're going to be placed on leave until the pandemic subsides. So, and so far the courts have held those up. So just something to keep in mind as an employer and as you're dealing with requests for accommodations or pushback on vaccine mandates, masking rules, whatever your policy may be, that should you be able to make a business case and in the vein of reducing that direct threat to your fellow employees or to the general public or whoever your business may serve, that you do have a leg to stand on there in many cases. So in terms of what's going on over in Washington, quite a bit, but quite a lot of infighting, I should say, and not a whole lot of progress. So if you tuned in, I believe in July was our most recent legislative update. We talked a lot about the PRO Act, which was, if passed, it did pass the House and it kind of stalled out in the Senate. But it would have provided a lot more ammunition for unionization efforts, a lot of traction in terms of reducing the number of workers who could legally be considered independent contractors. It'd push a lot more of those workers to W-2 employee status, and also create a lot more penalizing and financial mechanisms for the National Labor Relations Board to charge employers financially when they violate the rules of the National Labor Relations Act. So as I said, most of that stalled. A lot of it will go to agencies. One thing that they did try to put in the Build Back Better bill, which has also stalled to date, was that punitive damage and civil penalties piece. They're really pushing for that because as of right now, aside from back wages, liquidated damages, things like that directly to employees, the National Labor Relations Board doesn't really have a mechanism to levy big fines or penalties on employers. They can simply correct the action, get those affected workers their lost wages back and a little bit more, but they don't have the capability of really doling out huge fines and penalties to these employers who are violating the National Labor Relations Act. So they are looking to do so. They did put it in the Build Back Better. People are pretty pessimistic about that getting ultimately passed, so you could see some legislation hit the floor regarding that ability and those civil and punitive penalties. At this point, unless something is very bipartisan, we do have midterm elections coming this fall, and while that seems like a far way away in terms of the political news cycle and spin cycle, the legislators are going to start getting a little bit more conservative in terms of their ambitions and what they're looking to pass. And then depending on how the midterm elections go, it could create quite a bit of gridlock in Washington and even more frustration in terms of getting things done. So should that be the case, again, what we'll likely see is much more action at the agency level, as well as executive orders put into place. So if the House and Senate fail to act on some of the initiatives that the Biden administration was really looking for, they will turn to the agencies. So for employment law, again, that'll be the Department of Labor, that'll be the National Labor Relations Board, and then executive orders as well to kind of move their agenda along. One piece of legislation that does seem to have bipartisan support and we will expect to see passed this year is the Pregnant Workers Fairness Act, or PWFA. So what that'll be, it'll be similar to a lot of state laws that are relatively new but in existence, to basically create fairness for pregnant workers, and not just those who are having difficult pregnancies or high-risk pregnancies or things that need a tremendous amount of accommodation, it will put the onus on employers to provide accommodations to pregnant workers and to avoid anything that could be considered discriminatory. So you want to keep your eyes peeled for that. We'll have much more on it once it does come closer to passage and once we know the ins and outs of it. But do look for some legislation at the federal level protecting pregnant workers. The government did permanently extend the ACA deadline, so if you are an employer with 50 or more full-time equivalent employees, you're probably used to the various deadlines and having to hand out 1095-C forms for all of your insurance-eligible employees under the Affordable Care Act. So when the ACA was first passed, the original deadline to distribute those 1095s to the workers matched up with the same deadline to distribute W-2s, which is the end of January. But every year, and I think the ACA has been in effect for well over 5 years now, every year they keep extending that deadline, usually to March. So recognizing this, the government has now permanently pushed back the ACA 1095 deadline to the end of March. So give yourselves a little bit of breathing room there if you are under the gun for Affordable Care Act. And then as recently as this week, the White House is speaking with several tech companies because they're recognizing that there is an issue regarding open source software that's used to build many platforms and many technologies that businesses use and that their customers use. A lot of the recent hacking problems that some large businesses have been victim of has been as a result of hacks and security issues within open source software. Problem is a lot of open source software is maintained by volunteers, so it can be difficult to really have it kept to the same standards that more secure technology is. So the White House is meeting with several technology firms this week to try to figure out a plan to have open source software be a little bit more secure and not be a liability to the business world and really to our entire infrastructure. All right. So while everyone is really anticipating the Supreme Court ruling on the vaccine mandate, it is business as usual over at the Supreme Court. They are still hearing cases and issuing decisions. Some of the upcoming cases that they'll be hearing that could affect employment law are as follows. An interesting one with the airline industry where they're fighting to not be bound by state wage and hour laws for airline flight attendants, just based on where those attendants are housed or where their main base of operations is, because they spend so much time in the air and most of their work isn't done in their home location. So we'll see how that case gets sorted out, but it could have impact on other industries as well for employees who travel to several states or don't really have a solid base of operations. They're also going to hear a case about mandatory arbitration and whether it's lawful for employers to force employees into mandatory arbitration scenarios to resolve workplace disputes. And usually it'll be something around determination, whether the termination was lawful or what monies may be due to an outgoing employee. So it'll be pretty landmark to see how they rule on the mandatory arbitration case. They're also going to hear a case regarding the power of federal agencies and their interpretation of laws and the ability for employers and employees to challenge an agency's interpretation of a law. So that obviously bears a lot of weight in terms of the ability for a business to challenge an employment law that they, or a mandate from an agency that they feel is unjust. And then finally, the Supreme Court is also soon going to be hearing a case regarding retirement plan fees and whether, when those fees are excessive, whether it violates any of the ERISA codes. So that'll be interesting to follow as well, and could be quite a bit of a shakeup in the financial sector when it comes to retirement plans. So the IRS isn't typically an agency we touch on in this session. We usually stick to stuff that's more involving employee relations issues and things like that. But there was a pretty startling report released. It was either yesterday or the day before about kind of the crisis that the IRS is going through right now. So as of the end of 2021, they had a backlog of over 6 million paper returns and over 2 million amended returns that they're trying to get through. And by a combination of some budget cuts a couple of years ago, combined with COVID-19 and hiring issues and absenteeism, right now their staffing is basically at 1970 levels. So there's a whole bunch of people dealing with a mountain of paperwork, and then the phones are also ringing off the hook. So as things get delayed, that creates more inquiries into people calling in and wondering what the status of their return is, or calling to follow up on some correspondence, things like that. So as of right now, the IRS has 15,000 call center employees who are left to deal with 240 million calls that came in last year. As a result, based on extreme hold times and things like that, only 9% of calls into the IRS were actually answered last year. There are some tech resources as well. For individuals looking for the status of their refund, there is a Where's My Refund page that received over 630 million visits last year. So they're getting hit hard. They are kind of bracing people, telling them to expect further delays as the tax season formally launches later this month. Best practice here is really to e-file whenever possible. Also request a direct deposit whenever possible, rather than waiting for a paper check to be produced for any sort of refund or credit. That's the best way you can streamline things. We've seen that ourselves, that things that can be e-filed turn around in weeks, whereas paper returns and amendments turn around in a matter of several months. And the original windows that we've seen are now being exceeded. So when it comes to ERTC, the tough news there is that the IRS doesn't currently have a method for businesses to submit amended returns and claim employee retention tax credits electronically. There isn't an e-file option at this time. So unfortunately, those have to be added to the paper backlog. We're working closely, doing our best to help them realize quicker turnaround times, but if you are thinking about ERTC, the faster you can get that in, the better, in terms of getting those credits to you sooner rather than later. Okay, over at the National Labor Relations Board, if there's one agency to keep your eye on in terms of the latest and greatest with employment law and moving and shaking, look at the NLRB. They are getting really busy right now. So they're moving quite aggressively. They're hearing cases, they're inviting cases, they're kind of soliciting for cases on topics that they want to rule on. Right now, I believe on December 27th, they made a statement really looking for cases to help clarify independent contractor rules and in which instances they feel it's appropriate for a worker to be classified as an independent contractor, in which cases are really more of a employee-employer scenario. So depending on what case they accept and what kind of precedent is set based on the details of those cases, it could be really landmark, and it could create a huge shakeup in the business world in terms of who can legitimately be considered an independent contractor and who really needs to be a W-2 employee. They've also been dealing a lot with unionization cases and attempts for workforces to be collectively bargained. Some of the big ones that they've been ruling on recently have been Google, the New York Times, and Amazon. Google just lost a hearing with the National Labor Relations Board, I think earlier this week, where they were trying to withhold some information but are now being forced to provide it to the NLRB. They also said that the New York Times acted unlawfully in terms of how they treated, I believe, some of their tech columnists and journalists from forming a union. And then there's been a lot of back and forth with Amazon and the way that they've handled unionization efforts at different locations there. So there's a ton of scrutiny on unionization efforts, and something to be really mindful of. If you are of an industry that is at risk for being unionized, or things start to look like there's some movement going on, you really want to make sure that you're up on what the latest and greatest rules are in terms of what you're allowed to do and what you're not. You really don't want to run afoul of those rules, and they kind of are constantly changing between timelines for elections, what meetings you're allowed to hold, what you're allowed to say to try to dissuade employees from unionizing, what you're not allowed to say. So um, it is quite a minefield. So you just want to make sure you're up to date on what you can and cannot do in that arena. They are also weighing what can be allowed in severance agreements, and this could be huge as well. So there is some likelihood that they're going to disallow the following in severance agreements. So confidentiality, especially around the amount of a severance payment. So a lot of times severance agreements will say you agree to keep the amount, the terms and the amount of this severance payment confidential, and you also promise not to disparage the company in any way. Sometimes it'll be a mutual non-disparagement clause. It's looking very likely that those will get thrown out and not be deemed lawful in severance agreements. So and those previously had been enforceable. I don't know if you remember. I remember a few years ago there was someone who had signed a severance agreement. I want to say they were a judge or something, or maybe an attorney, but one of their children went on social media to brag about the amount of the severance, and that ended up costing them quite a bit of money because there was this confidentiality piece in the severance agreement itself. But we'll see where that goes, but it is looking fairly likely that those will get thrown out. And then another big case that could affect employers and affect handbook policies quite a bit is regarding Whole Foods and some of their policies regarding masks and kind of uniform and dress code. So you may or may not remember, but early on in the pandemic, when masking was really mandated and emphasized, there was a brouhaha over at Whole Foods because some of their employees wanted to wear masks with Black Lives Matters logos and Black Lives Matter statements, and Whole Foods did not allow that. They prohibited it from the stores. So there was a lot of back and forth. They eventually figured something out. I think Whole Foods ended up providing some approved attire. But the National Labor Relations Board just recently weighed in a couple weeks ago that they're going to be going after Whole Foods and saying that by banning the Black Lives Matters mask, that they violated those employees' Section 7 rights and their ability to discuss the conditions of their work, stating that racism was a potential condition at their workplace. So the Black Lives Matter mask was in conjunction with their Section 7 rights under the National Labor Relations Act. So we'll see how that case goes, but should it go a certain way, it may require employers to kind of carefully word their handbook policies when it comes to appropriate attire, to leave some wiggle room in there for attire that could be in protection of their rights under the National Labor Relations Act. So along with the National Labor Relations Board, the Federal Department of Labor is also keeping quite busy. In preparation for the presentation today, I like to look through some of the press releases and some of the action and some of the rulings that the Department of Labor conducts. And a lot of times they will release a press release, especially when it's a fairly sizable outcome against a ruling against an employer. And just looking through at what's come out just this year alone, just this month, and we're not even 2 weeks into the first month of the year here, but there are already nearly 20 different press releases with various fines and penalties for businesses. Everything ranging from overtime violations, not paying overtime correctly. There was something where they found some systematic wage and hour issues at cotton gin facilities in the southern U.S. There were some regarding retaliation. So they're hard at work, and they must be staffed appropriately to deal with complaints coming in, because they are going after quite a few different businesses out there. So it is something to be mindful of. You do want to really double check, triple check, quadruple check that your wage and hour practices and policies are up to snuff, because the Department of Labor isn't fooling around right now. Among those press releases, and not counted towards the ones with financial penalties associated with them, they did earlier this month announce an official partnership and info sharing agreement with the National Labor Relations Board. So as busy as both companies are, or both agencies are independently, they are now working together as well and sharing information. So if something's found to be in violation of one, or maybe they know it would be in violation of the other, they do now have a formal agreement to share that information. So again, just something to be mindful of there. Then there was a really interesting case. You may have heard about it. It made some of the news just because of the nature of it. But they did find against an employer. It was an auto body or a mechanic shop. They had an employee who got in a fight, an argument with the owner, and the employee quit. The employee then demanded their final pay, $931 and change that they were owed. The owner of the business, really felt that things ended on a sour note, was not happy with the employee and not happy about their demands for their final pay. So instead of sending him a check, the employer, either themselves or hired someone to drive over $931 in dirty, oily pennies and dump them on the employee's driveway. Not only that, so that obstructed their driveway, created a huge mess. I guess it took 7 hours for the pennies to be cleaned up. And then on top of that, they also included I believe a handwritten pay stub that included some expletives about the employee, and then also made some defamatory statements on the company's website about said employee. So it was quite a spiteful action, and ultimately the Department of Labor did side with the employee and ruled that the employee was retaliated against by their employer based on these actions. I don't know if it was any one more than the other, but they did feel that this was retaliatory. And as I often warn, when there is an issue with one employee, that can oftentimes open up the books to everything you have going on. So as part of this complaint, the Department of Labor did a more formal audit on all of their pay, wage, and hour practices, and found several other wage violations, hour violations. I believe they weren't paying overtime correctly. They were just paying a flat rate rather than actually counting the overtime hours, and some other stuff. So at the end of the day, the company has to pay $36,000 in back wages and damages as a result of dumping all these pennies on this employee's driveway. What some people may or may not realize is that OSHA, Occupational Safety and Hazard Administration, is an arm of the Department of Labor. So in terms of what they have going on, obviously a lot of this hinges on the vaccine mandate, because they will be the body that's in charge of enforcing that rule. So should the mandate stay in place, OSHA will be pretty busy and spread pretty thin when it comes to their day-to-day work, as they'll have to be enforcing this vaccine mandate. What we've seen so far, I guess similar to safety situations, and probably a little bit different, where they will be short-staffed should there be a vaccine mandate. OSHA's kind of acting in a reactive way at this point. Sure, there'll always be audits here, there, and everywhere, but in terms of timeliness, right now and as of late, they've really been responding to complaints. So if an employee complains about workplace safety, or that a company is creating a unsafe workplace, whether that be occupational hazards, not having proper safety equipment, having a truly dangerous workplace, or also that extends to COVID protocols. If employees complain that a business is not operating in a safe manner in terms of contagions and keeping the virus at bay, then those are creating OSHA complaints as well, and OSHA is responding to those pretty quickly. So if you do have employees complaining about safety, or how safe they feel in terms of COVID-19 related safety as well, you do want to do what you can to respond to that in-house. Make sure that they know the measures that you're taking, understand what the requirements are of you as a business, and show that you're meeting those to hopefully stop any OSHA interaction. So this slide is the same as our last go around, but Department of Labor is working off of their 4-year strategic goal kicking off this month. And it is a 4-part goal to build opportunity and equity for all. So they're looking really carefully at pay equity, any type of racial discrimination or systematic racism or other forms of discrimination in the workplace. They are really wanting to have OSHA more of a focus as well for safe workplaces. They do want to look into the administration of worker safety net programs, whether that be the Family Medical Leave Act or anything else that might be born under this administration for parental leave or anything else that might come about. And then they also want to be better in terms of their data collection and ability to have statistics and data that both federal agencies, state agencies, and the general public can lean on to understand what's going on out there in the working world. Another arm of the Department of Labor is the OFCCP, which oversees federal contractors. So a couple pretty important new things for federal contractors in 2022. First of which is a $15 minimum wage. There are some exceptions depending on the work that's being done in some other certain situations, but by and large, there is now a $15 minimum wage in place for federal contractors and those employees. And perhaps more so, and something else to really keep in mind is there's always been a requirement for federal contractors to have affirmative action plans, and historically they've just kind of been spot checked and spot audited. But as of this year, there is going to be mandatory reporting of each federal contractor's affirmative action plan. So there's going to be a website set up. Looks like it was just started up and just launched, where federal contractors are going to be required to submit and report their affirmative action plans. The window for doing so is going to be March 31st is going to be when the reporting window opens, and those will all be due by the end of June this year. The thinking there is that there will be some level of review of those affirmative action plans, so rather than just random audits where they're kind of looking blind, they will be reviewing the data, and ones that seem to be troublesome or potentially problematic, they'll then audit the practices at those organizations, those federal contractors. So if you are a federal contractor and you don't yet have an affirmative action plan in place, you will want to get right on that, because you will be required to report that later this year. The OFCCP is also doing a collaboration with the Equal Employment Opportunity Commission to really encourage pay equity and more inclusion amongst federal contractors, and working with businesses to have a more inclusive program for their hires. And they're also toying with the idea of a notification requirement whenever a federal contractor brings in subcontractors, so that they can keep on the up and up about which subcontractors are being used, and making sure that all applicable laws and regulations are being adhered to. Over on the state side, some interesting trends that we're seeing. A ton of states are enacting further restrictions or completely eliminating the validity of non-compete agreements. I believe Oregon is the latest, so their version of the legislation bans any non-compete agreement that's more than 12 months in length. So in terms of the non-compete period, it can't be longer than 12 months, along with some other restrictions. So that's something to be mindful of, especially if you're hiring across the country and hiring employees in different states. You want to make sure you're not having them sign a non-compete agreement if it isn't lawful, or if there are certain rules and requirements for those non-competes in the state that they're going to be working. We're also seeing a growing number of states adding natural hairstyles to their list of protected classes. North Carolina was one, and there was another state, I think Illinois, also added this to their list this year. Another thing that Illinois has done, which may sound kind of odd, and might be wondering what the applicability of it is, but in addition to standard protections for disabled people, Illinois has now extended disability protections to people associated with disabled people. So where this can sometimes come up is the onus of employers, and we'll have to see how this really goes when it comes to being challenged and going into litigation in Illinois. But I believe the thinking is that if you have an employee who may have a spouse or something like that who is disabled, then what are the expectations or requirements of employers to accommodate that employee? Or are we discriminating and not hiring someone because we know that their situation at home, they're associated with someone who has a disability that we may be concerned about their ability to do the job for us. So it'll be really interesting to see how that one plays out, but that is in effect as of this year. Another interesting one is over in California. So there's a fairly long standing, it's been around for a while now, but basically a requirement in California that if employees miss a mandatory break or a lunch break, that they're paid an hour of pay. And the interpretation of that hour of pay has always been at their regular rate or their standard rate, so what they normally make each hour. But the state has now further clarified for this year that their definition of regular rate is the same regular rate definition as it comes for overtime purposes. So for those of you familiar, regular rate in terms of the Fair Labor Standards Act means not just their regular hourly rate, but also needs to include and factor in commissions and other incentives and other pay that they're receiving to determine what their actual regular rate is. So on top of that, California has also made this clarification retroactive. So for employers who it isn't just enough to be doing that correctly going forward and making sure in instances where you're paying the hour for the missed break time, that if in the past you did it incorrectly and weren't factoring in the entire FLSA definition of regular rate, you could owe some employees some money. We are also seeing various states deal with COVID, either mandated COVID leave or the availability of COVID leave in different ways. Again, a lot of these do have reimbursements available. And based on what was passed, we kind of say California, Oregon, and Illinois were the most active. So if you do have employees in those states, make sure you do a bit of a deeper dive and make sure you've got a good handle on all the new laws and regulations in effect for 2022. So looking ahead, in terms of what we're seeing in the courts, kind of what's going on in terms of litigation, we are seeing COVID cases. Again, a lot of challenges to employer policies, employer mandates. But to date, as I mentioned earlier in the broadcast, the courts so far have generally sided with the employers in the name of public safety. So as long as an employer can make a business case as to why that employee poses a direct threat if they're not masked or not vaccinated or what have you, the employer has generally won those cases to date. Also seeing a lot of litigation around civil rights violations, discrimination in the workplace, unequal treatment. It can be really challenging when you feel it's okay for certain segments of the employee population to maybe work remotely or have modified hours and not so much for other groups. So it's really important that you have a non-discriminatory business-based case when you make decisions on certain things like that, and be able to communicate that effectively so that if people or employees tend to think the worst and just assume they're being discriminated against because of their disability or their race or their gender or other protected class, that you've got a kind of an ironclad paper trail of your reasons for making your business decisions. Also seeing a ton of litigation around overtime, again, that regular rate rearing its ugly head in terms of proper compensation to employees. You do really want to make sure if you do have employees who do work overtime that their regular rate is calculated correctly. Also a lot of challenges to misclassifications, whether that be employee versus independent contractor or exempt versus non-exempt. So employees being paid on a salary basis when they feel they should be hourly and eligible for overtime. Something to really keep a keen eye on will be if you do have employees who were perhaps legitimately exempt, salaried, having exempt job duties before the pandemic, but since then, or because of staffing shortages or whatever it may be, that their role and their responsibilities have changed somewhat, and they're doing a lot more what would be considered non-exempt tasks. You may need to temporarily or maybe even permanently reclassify their positions if their primarily focus of their job has shifted from exempt work to non-exempt work. So definitely something to take a look at. Also, a lot of kind of wage and hour around remote work. It's really hard as an employer to monitor when your employees are working or not, and when they may be, going over into overtime scenarios. So it's a really delicate topic and something that needs to be handled carefully. But remote work is becoming an issue with wage and hour, and on top of that, not just the actual wages and hours, but for remote workers, which state is in play here? Which wage and hour rules do you need to go by? Is it where the employee had been working previously in your corporate office, or now that they're working from home and that's in another state? Or maybe they're working some of the time in the office and some of the time at their home. Which state's rules come into play? So unfortunately, the answer on that is it depends. But again, something you want to really analyze and have some confidence that you're doing it the right way. And then also, again, litigation surrounding accommodations and what's reasonable versus what places an undue hardship on a business. So again, when it comes to COVID-19, the courts have really sided with employers in the name of public safety, but other accommodation requests not so much in terms of the bar that's set, that where an accommodation really causes an undue hardship on a business. That bar can sometimes be pretty high. It does depend on the size of the business and the accommodation request itself, but it is something you have to carefully scrutinize. We will also likely see some more wage and hour litigation regarding what's called the 80-20 rule. So I failed to mention it in my Department of Labor update. We kind of had a full slide there, but the Department of Labor just recently reenacted what's called the 80-20 rule. This largely pertains to restaurants, but other tip positions as well. And so the 80-20 rule basically states that when an employee is spending more than 20% of their time on non-tipped type duties, so not waiting tables, but doing some of that other work that wouldn't be subject to tips, if that creeps more than 20%, then the tipped rate is not appropriate for those hours. So if you do have tipped employees in your industry, you want to be mindful and make sure that their non-tip duties are not exceeding 20% of their hours. At least if you're paying the tipped rate for all of it. Okay, and finally, before we see what we have for questions, some things to look for and keep your tabs on, and definitely subscribe to our news updates, as we're always combing the latest and the greatest at the courts and at the agencies. As I mentioned earlier, there are going to be a lot of fights over jurisdiction. What employment laws are valid in terms of an employee's specific working situation, and then on top of that, which employment taxes do they need to pay in terms of withholding and unemployment and all of that. So no one case is the same with these. We are already seeing some states start to fight over who should be the state of record for tax purposes, but that will also extend to employment laws, because as you probably know, if you're a multi-state employer, the rules can vary dramatically from state to state. So expect to see some clarification and some more stern rulings over that topic. Also like to see some more action on independent contractors. So that could come from a number of different areas. A lot of states are moving towards more strict rules on independent contractors. A lot are adopting that ABC test that California and other states adopt, where unless all three prongs are met, the worker really needs to be classified as an employee. We'll see what happens there. It could come at the state level. The Department of Labor has dedicated themselves to addressing it, as well as the National Labor Relations Board. So expect some movement there. And again, as I mentioned before, just make sure you're keeping on top of unionization rules and what the rights are of employees attempting to unionize and what the rights are of employers in terms of how to handle that in their workplace and when they can and cannot do. National Labor Relations Board is looking at that very aggressively, so expect the rules to be modified in 2022 to some extent. Speaking of the NLRB, as they rule on different cases, you're going to want to make sure that your handbook and your handbook policies are up to date. One of the things that the Obama era or the Obama administration National Labor Relations Board was very famous for was really analyzing and deeply analyzing handbook policies and picking out language that might have seemed innocent on the surface, but they found to be chilling to employee rights. So based on what we know right now, there could be further scrutiny on handbooks and employee handbook policies. So as rulings come out and as decisions are made, you're going to want to make sure that you're updating your handbooks accordingly to not be in violation. All right, so let's see what we have for questions. We've got a couple minutes. Is there an OSHA vaccine mandate time that's being issued for staff to get vaccinated? So, great question. As of right now, the OSHA emergency temporary standard, as it's called, which is the vaccine mandate, would only, if it stays as drafted and as released, it would only apply to businesses with 100 or more employees. So if you're under that, unless there's something at the state level where you are, at the federal level, there's not a vaccine mandate for smaller employers. Should the over 100 employee vaccine mandate stand, if the Supreme Court supports it and keeps it going, that technically went into effect as of this past Monday. Enforcement won't really start until next month, but should it stay in place, then you're really going to want to make sure you've got your ducks in a row and that you get into compliance this month. Let's see, okay, a lot of requests for last week's webinar, so we'll make sure to get that to everybody. It was a really good session. All right, review the rules for what's considered the state of employment if someone is working remotely due to the pandemic or being moved towards a hybrid situation. So this can vary state by state. So in terms of temporary nature, if someone's been working at home because of the pandemic, most states have kind of abolished that grace period. So if you have someone who's still working remotely and working remotely 100% of the time, it's safe to say that wherever they're performing the work, that's going to be the state of record. And if you're not already, you need to be paying state withholding tax for that state, as well as most likely unemployment insurance tax in that state. And there may be other requirements as a business because you do now have an employee in that state if they're still working remotely, especially if it's 100% of the time out of state. I don't know of any grace period still standing in any state that was allowing a kind of temporary treatment of the employee where they were normally working when they were working on site. So if it is 100% in one place, you do want to consider that employee an employee of wherever they're working from right now. In terms of the hybrid situations, again, it can vary. It's really a patchwork from state to state in terms of what they consider employment. Sometimes many will follow the first day rule. Others will have a certain hours or payment threshold. But if you have someone regularly working between a couple of states, most states will just ask for the primary place of work. So whichever has the highest percentage. Sometimes it'll be 3 states. So if you have someone working in, let's say, Massachusetts, Maine, and New Hampshire, and they work 40% in Massachusetts, 30% in New Hampshire, and 30% in Maine, 40% in Massachusetts is the highest of those percentages, so they'd be considered a Massachusetts employee. So in that case, they'd be eligible for paid family medical leave here in Massachusetts. But similar rules apply in other states as well. You generally want to see where is the majority of the work being performed, and whichever has that highest share would be the state of record in terms of employment. Does the ARPA sick leave credit reduce the amount of payroll taxes. Yes, but just to be clear, ARPA did end on September 30th, so ARPA is not in play anymore. You would not want to apply ARPA leave to any wages paid after September 30th, with the one exception of an employee who started their leave on or before September 30th and it carried over into fourth quarter. Those are allowed, but other than that, you shouldn't have any ARPA leave listed or any tax credits claimed for fourth quarter of last year or first quarter of this year. If you are in a state that has a COVID sick leave, that would be separate, and the states have different ways for being reimbursed and credited for those. But just to be clear, the federal ARPA program did end on September 30th. Let's see. In terms of signing up for future webinars, if you registered for this one, you should be good to go. You should get invites to the future webinars. Are employers required to maintain documentation of vaccination status for remote employees? So if you are subject to the emergency temporary standard and it is kept in place, it's not a requirement for the remote employees if they're 100% remote and never coming into the office. But if there is going to be a time where you're going to call them in or they're going to need or want to come into a physical work location, then they will either need to have that vaccination status on record, or they would be subject to the testing requirement if you allow that. So for the week that they're coming into the office, they will have to have a negative test and be masked. Any discussion about tracking vaccination status? Yeah, so definitely HR systems, ours included, can be set up to track vaccination status. It is a good idea, especially if whether this mandate passes or fails, or if something else comes of it. It's good to have a record of that for many purposes. It also can, if you do end up having a positive case, and you're following CDC guidelines, someone's vaccination status could play into what actions you need to take, how long they need to be away, when they should be tested, so on and so forth. So it's a best practice, and it's also compliant in terms of keeping vaccination status on record, as long as you're keeping it confidential. Are boosters now required? No, not at this point, at least at the federal level. Fully vaccinated is still defined as 2 weeks after the second dose of a Moderna or Pfizer shot, or 2 weeks after the Johnson & Johnson shot. They have not yet modified the definition of fully vaccinated beyond to include boosters at this time. Getting some questions about Colorado emergency sick, so we'll try to include some information about that. Can an entire company be exempt because of religious reasons? No, I don't believe so. It looks like we're coming up on time. We're right at 2 o'clock. So thank you so much for your time today. And thank you for all your great questions. I will hand things back over to close us up.
Thank you, Paul. Lots of great information on a complex topic. Any questions that were not able to be answered on today's program will receive a response via email within 5 to 7 business days. The MP HR team is here to guide your organization on any HR compliance issues, and they are especially well versed in the policies related to the legislative updates. If you would like to learn more about how we can assist your organization, please visit our website to set up a short 15-minute call. Be sure to join us next week on the same day and time for our webinar on the Great Resignation to learn the best practices to retain your workforce. Visit our website to register and to see the full calendar of upcoming events and available resources. We will be sending out a recording of today's webinar with the presentation slides, along with a recording from last week's vaccine webinar this afternoon. Thanks for joining us today, and have a terrific day.